This meeting is being recorded.
So I want this video to be about an hour long. So what me and Jody were just talking about is that whenever we put in our case using anything using our 1688 will and Mary, our constitutional law, the highest law in the land, highest law in the world, really, that all Anglo people are governed by, that was the governance structure that all of the ships that went out to all of our Anglo countries, the promise was that we would be forever permitted to govern ourselves. We would be forever permitted to petition to the Supreme Court and then directly to the King if any of our rights under that 1688 will and Mary, if any of them were violated or blocked or stood upon. We had that promise. That was the condition, that these ships were sent out to build these countries. What they've decided to do is give us all these human rights. What they've done with the human rights is they've categorized everything into a group. So you have to belong to a group. Now, if you go and look at the human rights, the only way that you can get a case into the court, you have to belong to the homosexual group. You have to belong to the ethnic minority group. You have to belong to, you can belong to the children's group. You can belong to the disability group. You can belong to, but our 1688 Bill of Rights is specifically for the Protestant group. And what are the Protestant groups? Well, you have to go back to the beginning of time and the beginning of Jesus when the laws were first made. And what happened with the first one that was made was the Catholic Bible, and they wrote a whole bunch of laws for, so somebody came along, somebody just turned up one day and said, hey, I'm going to start a religion. And all the people that came to join, they put all their land into the ownership of the Catholic Church. And then the Catholic Church let them use that land. So the Catholic Church owned all of the land for those people. The Catholic Church, it was a protection order. They said, anybody that's in this group is protected, and if anyone comes and invade, we will attack them. They also made many, many laws for the Gentiles. So anybody was not born to that group, you had to be born to that group. Anybody that was not born to that group was called a Gentile. And the Gentiles had many cruel punishments laid against them if they didn't follow the orders of the people that were in that Catholic group. Now, Martin Luther, in around about 1500 or so, he rose up. He had entered the monastery. He had been a Catholic for many years, and he rose up. Well, let's go back. Let's just back up for a bit from there. So that was that group. And then another group, another man came along, and he said, I'm going to start my own religion. And he started up the Jewish religion. This is just in very rudimentary description here. So he started up his religion, and he said, right, and he created a language. So first of all, he created a new language that nobody else could read, only they could read. That was the same for the Catholics as well, by the way. All the people couldn't read. They created a language, a written language, with a class of people that could read. So the only ones in their group that could own land was their class that could read. Everybody else was under God and be called the terra nullis, no different from an animal. And since they couldn't read, they couldn't own land. So this next group, the Jewish group that came along, they created a language. They created a whole new religion, which was semi-based on the first religion. And then they turned around and said the same thing. You have to be born to the religion, and if you're not born to it, then you're a Gentile. And the Catholics and the Jewish groups both agreed not to interfere in each other's laws, but they also both agreed that everybody that wasn't in their two religions went under the Gentiles. And so those people were subjected to many, many, many cruel and unusual punishments, because they would have laws to protect each other from each other. But they said, since those Gentiles aren't in either of these religions, then they're subjected to a different set of laws, which included, if you spoke against either of those two religions, tongues being cut out, having to wear mouth guards on your mouth, having the rats eat your innards out while you were alive, all sorts of things like that. Now, those Jewish groups went into Saudi Arabia, or they're around about thereabouts. Now, the Muslim people originally, we'd go back and research them. They originally were not Islamic. They were not. They were democratic. All their leaders were voted in, and apparently, as the story goes, what had happened was a lot of the Jewish groups had moved in and started to surround them and started claiming the lands and breeding into them and claiming the lands through the breeding in. So they were starting to lose their lands. And then apparently there were two leaders, two brothers, and one of the brothers said that he would pass on the leadership to the other brother on the condition that they kept the democratic. All their leaders were elected in. They were a very, very advanced society in regards to voting and electing their leaders. They were not under tribal rule, so to speak. Their leaders were voted. And when the Jewish groups started to overpower them, they realized that they needed a religion. So they started the Islamic religion. And so then they created a language and they created all of their laws. And so there were 3 sets of laws, and then anybody that wasn't born into that area were out, and they were called the Gentiles. Now, fast forward a couple of thousand years or whatever, Martin Luther in Germany, he had entered the monastery, and these cruel punishments that were being inflicted on all people that were not of those 3 religious laws, because all the people outside of that were considered to be lawless people. And so they were considered to be, you could string them up and cut their throat just like you would a sheep today or a cow today. They were absolutely no different whatsoever from a cow, and you wouldn't be prosecuted for it. And yet, if you strung up a Jew or a Catholic or a Muslim, if you strung any one of those up, you would be prosecuted for it, and you would be punished by their leaders. But anyone that was not in those 3 groups were no different from a cow. You could string them up and cut their throat, and that's exactly what they were doing, cutting off their heads and putting them on the posts of the Catholic Church and all sorts of things that they were doing. So Martin Luther rose up. Now, out of that came the King James Bible. Then the King James rose up, and that was a law that could be considered for everyone. It was the original universal law, because it had in it all the cruel punishments of the 3. Well, so the Catholic was in Latin, and of course the Jewish was in the Jewy religion, and the Islamic was in the Islamic, and nobody could read those texts. So none of the Protestant people were under any of those laws because they couldn't read. Well, that when Martin Luther translated the text of the Latin into the English language, and all English comes from the German languages. So English is actually an offshoot of German languages. It comes under the categories of German languages. A lot of people don't know that. Thousands upon thousands of Protestants were shipped out to England, Scotland, and Ireland to battle against the 2 religions of the Catholic and the Jewish, and then the Islamic went all over the Asian area. So and then the Protestants came in, and then that was the battle in England, Scotland, and Ireland. That was the battle, is that when originally the Irish were trying to throw the German Protestants out. So thousands of them had fled from Germany and Europe to the safety of England. But then what happened is those two religions then went over to England as well, started up all the same stuff that they were doing, all the cruel punishments. The original 1688 Bill of Rights is actually a protection order. It's no different from when a man beats up a woman and she goes to get a protection order against that man. That's what the 1688 Will and Mary was, a protection order against the three religions that were slaughtering them and chaining them up and doing all those things. So the Irish, the Southern Ireland started fighting against Northern Ireland because the Northern Irish were mostly of German Protestant stock. And so they used to call them German ladies. And I was called by an Irish friend of mine, a little lady, you wee lady. And I said, oh, what's a wee lady? She said, oh, you're a wee lady, are you? And I said, oh, what's a lady? She said, oh, it's just a nice name that we used to call people, but it actually is not. It's like calling someone the N-word. So they would call them German ladies, which meant that they were not born to Ireland and they were the invading species. But what had happened now in Scotland, they had the Jacobites, which were fighting against the Protestants. And what had happened was when Ireland and Scotland were fighting against England, they realized that the fight was actually not against England or the Germans. They realized that the fight was against these religions that were trying to force upon them all of these laws that they wanted them to follow. And they wanted each state to be governed by those laws. And so all the people said, so that's when they rose up and joined together with England and got them all out, right? So that all spilled over into New Zealand and Australia. Now, where am I going with this? So that's kind of the basis of where all the laws have originally occurred, right? Now, what has happened is that there's been a transfer of that. They've decided to try and put us all under the Noahide laws at the United Nations, where they're going to go back to the original Jewish and Catholic and Islamic laws, the original ones, but then they've put in there that there's only 7 laws that they've ordered, that there are 7 laws that we Gentiles have to follow. And one of those laws is no harm. It's really, really a dangerous law because under their 3 sets of laws, it is a harm to speak against them. And the punishments for speaking against them are horrendous. And they were all the punishments that we needed the 1688 Bill of Rights to protect us from. All those punishments are going to be brought back again, because it's the crime for speaking against them is decapitation, tongues cut out. And so this is all this hate speech that they're trying to get in. So what had happened is that, as you know, that I went to the court and I'm trying to bring in the Will and Mary, and I'm trying to get a ruling to claim my subject status to get my protection order back. And so it did go to the appeals, but we got stuck on the fees. Under the 1688 Bill of Rights, it says that we have the right to petition the king, and all commitments for doing so are illegal, which means we don't have to pay fees. But when we go to the court, the only thing that they will acknowledge is human rights. They keep saying human rights, human rights. And this is where I get to with Jody, where we started talking when everybody would have come in the video, what we were talking about. Jody knows all this already. So I just did this for the viewers. But what we're at is that every single case that's going through the court is using human rights under the Noahide laws, what they've done is they've created a whole bunch of groups that are not Protestants. And you'll find that almost anybody belongs to those groups unless you're a Protestant. If you're a Protestant, you can't even get in there. And so they're saying that your court case has to be in the public interest. And if it's in the public interest, you have to belong to one of the groups that the human rights has decided is a group that can go there under the human rights to get your petition to the court. So the groups are the homosexual groups. Well, I'm not a homosexual, and not that I'm against them, but I'm not one. You can be in the children's group. Obviously, I'm not in the children's group. You can be in the disability group. I'm not in the disability group. Here's Maxine. Maxine's been helping a lot. You can be in the ethnic group. Any of the ethnics go into it. So as long as you're brown or you've got a disability, so children would come under disability as well, because it's anybody that can't really care for themselves, they get a group. All the brown people get a group. So you can't get a group if you're white. If you're a white, able-bodied Protestant person, they considered that you're not worthy of claiming any rights for yourself because they have not given you a group. You used to be able to go under a woman's group, but they have just recently decided that they're going to take women out of the equation. They've decided that all of the family planning places and all of that, they're no longer going to use the word mother, and they're no longer going to use the word woman. They're going to use the word whānau, which kind of means family. And so so the women's group is going to be out, but if you want to be involved, if you want a women's group, you've got to, you have to belong to one of the women's groups that they set up. So it has to be either you're the lesbian women's group, or you have to be, you can't just be a woman that says I'm a woman, or I'm just a group of women that we just stand. You can't be that. You have to be a women's group that's fighting for some kind of cause, a women's group that's fighting for human rights, or a women's group that's fighting for Indigenous people, or a women's group. So you can't just be any old women's group. So unfortunately, I don't come under any of those categories. I'm just an able-bodied person that doesn't really belong to any of the religions that I would come up. I only want the Protestant protection. So therefore, I am not able to get into a public interest because I don't have a group, because they deliberately made it so that any of the people that left England, Brent? Brent, turn off the sound. Brent. Turn off the sound.
I did.
Brent. All right, it's off. All right, so now I'm lost. Jody, where was I?
Not fitting into any group.
Right, not fitting into any group.
But this is where it's under our 1688, we should be able to get into the courts.
Under the 1688 and the 1908 Declaratory Judgment Act, now this was a protection order that was given to us. Well, a lot of people don't understand what it means to be a subject. What had happened is that they removed, when they made us all subjects, what had happened was when all the Protestants spilled over into England to fight against the three religions, they made us all subjects. When they made us all subjects, a lot of people don't know that this, but under a subject status, you're not permitted to buy pure title land. The second that a subject negotiates with any native in the entire world to buy a piece of pure title land, that land is immediately confiscated from them and given to the hands of the king or the queen of the time. Then that king or queen will go and see that native. They will say, do you want to sell this land? If the native says yes, then the queen will buy it, and then the queen will give back only a paper title to that subject. And so this is why the supremacy law is not, this is what they're talking about, the supremacy law. They had put this huge restriction on people of subject status from buying lands from all the natives. So when those three religions spilled out into all of the countries, going there to buy it, because none of those three people in those three religions are not subjects. Did you know that? The only people that have subject status are Protestants. Anybody that's not in those three religions comes under the Protestant status, and they're the only ones that have this subject restriction on them in regards to buying pure title land. And that's why a lot of them want out of it. What they've got is, it's a little bit sneaky, because what they've got is this subject status law restriction on us so that we can't buy native lands, but the payoff of that for us was we got to hold the governance. See, so one held the land and one held the governance. So that's how they did it back then, is they said, right, only Protestants are allowed in our Commonwealth parliaments, and all Protestants, if you make any laws to hurt them or affect them, these rights, they're permitted to take the government directly to the Supreme Court on any question of law and ask them. So we go directly to God. But the loss of that is that we as subjects are never, ever, ever allowed to buy pure title land. Now, what they've done is, so that's when they put all of our people onto the ships, and they sent us out to the various countries that were getting invaded by these three religions. So they sent us to America, England, New Zealand, Australia, and also were sent to England, Scotland, and Ireland, Africa. They sent us to all those places. And the reason why only Protestants were allowed to go and build those countries, and only Protestants were allowed to set up their governance, is because they were never, ever permitted to buy a single square inch of pure title land. We still can't today. But on the other hand, the payoff for the native people was that they would have people in their parliaments that were never allowed to take their lands from them. So it worked out, that's how it was. So originally, whenever people wanted to enter any of our Commonwealth countries, they had to swear allegiance to the Queen and make themselves a subject. That's why we didn't have any Muslims in our countries, because none of them from those three religions wanted to make themselves subjects, because the minute that they made themselves subjects, they would lost their ability to purchase pure title land. So that's why they never came to our countries, and that's why Catholics, because all Catholic land is pure title, all Islamic land is pure title, all Jewish land is pure title, and all Protestant land is paper title. So that was the sacrifice that we had to make. And so what they've done is they've kept this restriction on us, but then they've come up with these human rights, and they've tried to remove all of our rights except for that land restriction. They've kept the land restriction on us, but they've taken away all our Protestant protections and Protestant rights and placed us into the human rights. but the human rights has created several groups of which we're not able to be a part of. So that has removed our ability to get into the court to go against the parliament, because half the people in our parliaments now, Rishi Sunak, by our 1688 will and Mary, it's illegal for him to be in parliament. He's a Hindu for a start. I did do a video about them changing the oaths. Yeah, we did that last time. And not only that, he's born to 2 foreign nationals. So that would exclude him for a start. And they are of royal power. That would exclude him as well. So that's basically exactly what they've done. They've kept the restrictions on us in regards to land, but that restriction doesn't apply to any Asians. It doesn't apply to Muslims. It doesn't apply to Catholics, and it doesn't apply to Jews. It only applies to Protestants. And what they've done is they've let a whole bunch of those people into our country. And then what they've done is they've taken all our native people. Our New Zealand Maori were the only native people in the America, Canada, South Africa, Australia, and New Zealand. Our New Zealand Maori were the only ones that made themselves subjects. And there's a whole video on that, but I won't do it now. When they made themselves subjects, they became the leaders of all the native people in all our Commonwealth countries. The reason why they were permitted to have that ability was because they were of subject status and they were not allowed to buy up those lands. Right. Wait, Brent's going to ask a question, but just wait for me a minute. Now, so what they did was the New Zealand Maori in 1975, with the Maori would have been oblivious to all of this stuff here. They really would not have known. So, because it's even hard for us to know. We don't even know until a couple of months ago. So how do you expect them to know? So they took them up. They said, you're going to be the leaders of the Indigenous people. And they got them to remove their own subject status. And then they scooped them up and put them into the United Nations under the human rights law and the Universal Declaration of Human Rights. And then they scooped up all the Australian Aboriginals, all of them, and they put all of them under the Maori, and all of the refugees and all of those all under the New Zealand Maori. But you might ask yourself why they've done that. Well, they've done that because now they're bringing in the human rights. They've done that because when they bring enough of those people into our country, and enough of those people are allowed to govern, when they remove the Queen, right? It doesn't even matter if they remove the Queen. When they go republic, it does not even matter. We Protestant Anglo people are still bound by that covenant as subjects. So we're still bound to it. But all those people that are coming into our country are not bound to it. And if their lands are released from the Queen, which they have been and now placed in the UN, those people are going to be able to buy those pure title lands. And so this is the reason why they're now putting you in a digital title. They're no longer giving you paper title because they're going to hide where all those pure title lands are going to be sold to once it's fully released. So there's a whole big thing going on. So I've been trying to get into the court, and my battle is the 1990 verse the 1688. Now, before I go to the court ruling, I needed you to know about those human rights, because that's going to come up a lot, because the only time that they say the only time that your case is public interest is if you come under human rights. But whereas our indubitable Protestant rights under 1688, we can go as an individual. Under their human rights, if they lose the case, they have to pay. But if they win the case, the New Zealand people or the Commonwealth people have to pay them. But under our Protestant rights, it doesn't matter if we win or lose. If we win the case, we get a declaration and the law is changed to uphold our rights. If we lose the case, we're not supposed to lose any money either. And we're supposed to be able to go and petition as an individual. It's that they're blocking us from doing, but they're allowing the other group to go. So before I go on to the ruling, does anybody have any questions there? But need to keep them stayed on focus. So you can ask a few minor questions, but try not to get too big because we've got to get on the court ruling. I only want to make it a 1-hour video. So are there any questions there? Brent? No. Right, Maxine knows all of this. And Jody, you know what I'm talking about. Right, so nobody's got any questions. So we go to the court ruling. So we did go to the court ruling. Now I've got some cases here. Well, I'll go to the court ruling first. So when we went, we got thrown out in the first court, and then in the second court, we applied for a fee waiver. Under the 1688 will and marry the right to petition and all commitments for doing so are illegal, which means any fees are illegal. We got turned down on the fee waiver and they asked for $10,000 in deposits and court costs and things. And then I appealed the registrar's decision, and then that went to Judge Brown. When I went to Judge Brown, I said, I'm claiming my subject status. I don't want to be a human. I don't want to be under your human rights. I want to go to the court under my 1688 will and marry, and under that, I have the right to petition on a question of law, and I don't have to pay any fees for doing that if I only have a question of law, and I'm not claiming any pecuniary gain. I'm not getting any money out of it, right? So then I lost that case. He said, you're not a subject, you're a citizen. Brent! Turn your sound on. Oh, right. Fred. It's ADHD. God. So then I appealed that decision to the Supreme Court. When I appealed that decision, because all the people that went on the ships pre-1852 Constitution, they all were given ordinances. These ordinances were acts of Parliament. There are ordinances in America, South Africa, Australia, and New Zealand. There are Scottish ordinances, German ordinances, Irish ordinances. I don't even know if there's English, British ordinances. I don't think they are. There are. And so those people were all promised before they even were allowed to step foot on the soil of any of these countries that they're calling us colonizers, but we were not. The 3 religions previously to that were the colonizers. And then our people were sent on ships as Protestants with the subject status restriction of buying lands. In its pure title, we weren't allowed to do it. And so we were sent on ships to counteract the actual colonizers that had bought up all the pure title land. Now, the Aboriginals in Australia and the New Zealand Maori and even the Indians were all incredibly lucky. It was just a stroke of luck that when they, from 1688, anyone that was born to that country came under that subject status, whether they wanted to or not. They were forced. So it was just only very lucky that all those people from those 3 religions that brought up those lands, the king came in and he said, you're all subjects and I'm not letting you take their lands. And he took it all back. And then they opened up courts and they said, from now on, the only people that you can purchase, the only people that natives are allowed to sell their lands to are people of subject status. If they want to sell their pure title land, if they try to sell their pure title land to anybody that is not of subject status, that was prevented, they were prevented from doing so because they were selling the lands of their tribes, because they came under tribal rule and all the land was owned by the first son. The first son owned the pure title land. That's the first son. And so they were taking that pure title land and selling it. But the land belonged to the tribes. So the tribes was, one day they had a little house on their land, and the next minute they were thrown off it and said, this is no longer yours because your chief sold it. So they also put a restriction on them that they were not permitted to sell their pure title land to anybody that wasn't a subject. So that was how they did it. So that's why they sent out all our ships. But they said to us, they said, don't worry, because you're going to have control of governance. And the only people allowed in our Commonwealth parliaments are supposed to be Protestants. Muslims aren't allowed in, Catholics aren't allowed in, Jews aren't allowed in. It's only because, why aren't they allowed in? Because they don't have subject status. So they can create laws where they're going to be allowed to buy these lands in its pure title form. And the natives will lose it. It'll be gone. They'll never get it back. This never will happen for them again. It never will. What happened for them back then. So now where am I up to? Now where am I up to? Lost myself. So get into the court case. All right. So we were sent on the ship. So I had said to the court of these ordinances, I'd said to the court, they hold the land, but we hold the governance by our ordinances that said that we wouldn't be permitted to buy pure title land, but we would be permitted to run the governance of the country. And that's why they're calling it white supremacy, because it's that they want to get out of. They want to get rid of that. They want to force us to keep our subject status so we can't buy lands in pure, but they want to take away all our rights of governance and that governance over ourselves. They want to take that away, and then they want to open it up so that all the natives can sell their pure title land to all people that are not of subject status. And you've only got to look at the United Nations human rights and ask yourself who all the people are that are not of subject status. They're all the Browns. They're all the ethnics. They're all the refugees. Anybody, almost anybody on the planet that's not white is not a subject. And almost everyone on the planet that is brown, browns are not, almost everyone on the planet that is white is a subject. And everyone on the planet that's brown is not a subject. But the people of Australia and New Zealand, right, and also the Scottish tribes, the Irish tribes, and the Germanic tribes, all of them, they brought us in to protect them from all the other browns, the Asians, the Islamics, all of those, from buying their pure title land because they were going to lose it. So it's just by the grace of God that they had sold it all to white people. If they had have sold all that land to Asians or Indonesians or any of them, they never would have been able to get it back. It was just by the grace of God at a time in history. The 1688 had only been around for around about 150 years, which is a very short time for a constitution to be around. It was short. So that's why they were able to keep all their pure title lands. That opportunity, if they lose their pure title lands outside of the Queen again, that opportunity will never arise for them. It's gone.
Kate, I've got one question.
Yes.
Back in that time, Queen Victoria made the Māori subjects as protections for them. So how does that work as well with the land, the subjects? Because there's subjects, but this was the agreement that the Pākehā and the Māori made with the we can govern, but they've got their own court, right? They were given their own court and so forth, and they can have the pure title. We get paper title. Is that correct?
Yes, that's correct.
But they are still given the protections because the Māori were adopted by Queen Victoria.
All
Just
right,
just
so
putting it out there for everyone to sort of understand. The Māori are still subjects as well, Protestant subjects.
this is a very good question, because I did want to just touch on this. I've touched on it before, but I really wanted to do a video on it. But that was a very excellent question, and we will just touch on it now because I'll get that touched on right now. Is that you have to go back to Scotland, and then they had a Jacobite king who was involved with all of the religions as well. And so that battle of the Protestant versus the kings of the the two religions, all right, that battle was going on over there. Now, the United Kingdom, the entire United Kingdom was run and governed and owned not by an English. You have to remember that England was not an English-speaking country. All the people that went in there were invaders from France, not Germany. They were, and so the language, the first, 5 or 6 or 7 or 8 kings were all French in the original, not English. There was no English spoken. And so the English came from it actually comes from the German language, because of all the Germans that went there to battle against these religions. And now, so they were called, the kings were called, those ones were called Jacobites. Jacobites were the Jews and the Catholics mixed together that were trying to get everyone under their biblical laws, all right, with their tortures and everything. And then, so that was under a king called King Ernest Augustus of Spain, I think. And Ernest Augustus was actually the king of the entire United Kingdom, but he was over there in Spain. Then what had happened was he was King's Bench until right up until, even though the 1688 was brought in the years around about 1700, those religions split from it, and they said, no way, we're not gonna protect these Protestants. They wanted to keep up their cruel and unusual punishments, and they did not want us to have our own parliament where they were not in charge under the Magna Carta. They had the Magna Carta. We had flipped it to get the 1688 above the Magna Carta. That's what we did. The Magna Carta was only for those religious leaders. And then we brought in the 1688, which said, you have your laws as religious leaders, but we'll have our Protestant protection here, and we'll govern ourselves, thank you very much. And then those religions come around and started fighting, and they spilled out into America, New Zealand, and Australia. And they set up shop in those countries and started buying up all the pure title land. And then, but that was all done under King's Bench. In 1820, King's Bench split to another law company called the Queen's Law Company. That was upon the birth of Queen Victoria in Germany. When she was born, the Queen's Law Company started under the Butterworths, and there's Joseph Butterworth and Henry Butterworth. I think it's Henry Butterworth that went and did the Queen's Law, and Joseph Butterworth was continuing to do the King's Bench law under King Ernest Augustus, who was a Jacobite king, and he ruled all of the United Kingdom, right? This is pre-New Zealand coming in. Australia's not even in the game. It's only New Zealand that's in the game here. Now, when the Queen's Bench Law Company opened by Henry Butterworth, and when Queen Victoria, when the king died in 1837, when Queen Victoria took her reign, at that point they were battling to get King Augustus out. And then the German queen came in, and so all this fighting's going on over there. There's a whole lot of fighting still going on for England and Scotland and Ireland, still going on. Now, 1837, Queen's Law came to power, and Queen Victoria teamed up with Tamati Wakanene, one of the Maori chiefs, and his brother, called Irawira Patuoni. Those two were secretly working with Queen Victoria to get King Augustus out and his rule and his family rule out of the UK. So they brought in Queen's Law into New Zealand in 1839, and it was proclaimed on January 14th of 1840, right? Now, Tamati Wakanene and Irawira Patuoni, you have to be careful, there's two Irawiras. One Irawira is on the Catholic side and one Irawira became a Protestant. So those two lived from 1820, along with Queen Victoria. These three people lived from 1820 right through until 1872, or it might have been even it was very late. They lived long lives, the three of them. And what they did is they gave all these ordinances, and they sent out ships of Protestants to counteract the colonizers. Now, those missionaries were colonizers. They brought up all the pure title land. She, together with them, they scooped up all the land. Now, Tamati Wakanene, now, my German ordinance was created in 1844, and the ship arrived, I can't tell you the exact date, but the ship arrived and the people weren't allowed to step on shore until the next day, when a parliamentary act had been made, making them, my ancestors were from Germany. The parliamentary act had to be made in Parliament before the people on those ships were permitted to step foot on the shore. And so that stopped them from buying the native lands. Now, Tamati Wakanene in 1847, they made him a subject. Now, why did they make him a subject? Well, you have to go and look at Queen Victoria. Queen Victoria, she owned all the land, but she wasn't allowed to govern. The governance was with the people, and she kept the land, and that stopped foreign entities from coming in and buying up your lands behind your back, and you became a vassal state. So Queen Victoria, so then what, we had a white queen, but what did we need? We needed a brown king. So Queen Victoria was restricted in that Queen Victoria was not allowed to buy pure title land in a personal capacity. She was only allowed to hold it in her basket for all the Commonwealth countries. She only held it in a basket. She wasn't actually allowed to own it. If she actually wanted to purchase land, she would have to purchase it as an individual in a paper title, just like you and me. She had her crown lands, which were pure title lands. She had some of those to give her power, but they didn't actually belong to her. They belonged to all the people of the country. And then Tamati Wakanene, what did she have to do? She had to do the same thing to him. She had to restrict him so that he couldn't purchase all the pure title land for himself and sell it out from under the other leaders. So she made him a subject in 1847, put him on a government salary. He was a king on 3 coins. He was on, I don't remember their names, but King Edward and then another king, and then on Queen Elizabeth. He was on all three coins. So you can equate Tamati Wakanene, the Maori, as being an equal. He was the brown king and she was the white king, if she was a king, but she was a queen. So she was the white, and originally he was a king. So the king came after her. Tamati was the brown king, and all the native people went under him. And they didn't all become subjects, but the New Zealand Maori became subjects, just like the Anglo people became subjects, to stop them from going over and buying the pure title land of the Aboriginals and the Islanders. And so what was done to the Anglo people was done to the brown people too. It was equally done. And so that's why the United Nations has put all Indigenous people underneath the Maori. 1975, the Maori went to the United Nations and announced that they had no right to make them subjects in the first place. They had their subject status removed so that they're back in a position where they can buy pure title land. But although they're in the position where they can buy pure title land, they're also in the position where other countries can buy their pure title land. And so they're doomed to lose it eventually. So it's a bit off topic. So in 1901, through the works of Tamati Wakanene and Queen Victoria, King Ernest Augustus his kingly line was cut, severed, ended. And in 1901, I think it was 1901, maybe before, he was no longer the owner of the United Kingdom in his kingly status. He was a Jacobite king. And in 1901, the Australian Constitution came to power. So the New Zealand Maori were already with Queen Victoria long before Australia ever was. It only occurred for Australia in 1901. And that's why New Zealand actually has more power. So what they've done now is they've put all the New Zealand Maori with all their pure title lands, trying to take it out of the Queen and put it into the United Nations as their protectors. So they've left that, and they've done that. So then I've gone to the court and I've said, well, hey, they can do that if they want to, but if you want me to keep my subject status, then I get these rights with it as well. If you're going to take away my rights, then you need to take away my subject status as well, and I should be allowed to go and buy pure title land as well. So that's what I'm saying. I'm saying, because there is a law that's saying that you can't get a benefit of a law. If there's a law, see, often laws have got they're two-pronged. You get this, but you lose that. But you can't just only take the bit where you get the benefit and then relinquish the bit that you lose. So you're not allowed to get that benefit without this loss here. Do you see what I mean? So we got all the benefit of the governance and the protections, but we got a loss because we lost our right to buy pure title land. That's a hell of a loss. That's one hell of a loss. It's huge. The other natives, they didn't get the power of governance, but they kept their right to buy pure title land amongst themselves. So they could do it together. So they're trying to get us under the human rights, keep the restrictions on us, release the Maori of their restrictions, keep the restrictions on the Anglo people, and then they're preventing us from going to the court with our rights because they've said you're not allowed to have those anymore because you don't come under the public interest, because you're not in any of the groups that are in the human rights, because we cannot be, because we're Protestants, so we're just not able to ever be in there. Unless you want to make yourself a homosexual, then you can get in there if you want to do that. But if you're not. So I'm just going to open this ruling, which everybody's waiting for. So that was so that's how that happened with the Maori under the Jacobite king. And they're trying to bring the Jacobite king back, because under the Jacobite king, the Maori at that point in time were not subjects, and many of the Anglos were not also. So that's why the battle that's going on. Now we'll go to our ruling, and then he has said similar. Hope that's all on record. Right, can you see that there? Right,
Yeah, that's good.
So here's the court ruling from Peter Greenhow. And Peter Greenhow, he says, on November the 26th, 2022, the registry received your application for leave to appeal, along with an application for a fee waiver to the Supreme Court, filing fee of $1,100. This application was made on the grounds that proceedings concern a matter of genuine public interest. And I'm saying that I have a genuine public interest in regards to the 1688. But they only recognize the genuine public interest if you belong to the human rights. So they're not recognizing it from us.
And I don't think you need public interest under the 1688 anyway, because you can go as an individual.
No, exactly. So that's what they've created. And there's some other cases which we'll talk about another day. And Maxine's just sent me a brand new case which explains it all very, very well. So, and that's from Justice Palmer, which we all know Justice Palmer, don't we? So pursuant to regulation 52B of the Supreme Court Fees Regulations 2003, the fee can be waived if I'm satisfied that the proceeding is on the basis of one of the criteria specified in subclause 4, the main one being that it concerns a matter of public interest, or that it is unlikely to be commenced. He says, I'm not satisfied that the requirement of 52B is met, as I note that in your fee waiver application, you tick the box stating that if the application is refused, you would start or continue the proceeding anyway. I'm therefore not satisfied that this proceeding is unlikely to be continued in the event the fee waiver application is declined. Now, just take those people for the novices. Here's the fee waiver application, and you can get a fee waiver if you say that it's unlikely to be commenced or continued if the fee, unless it is waived, right? But we did see another case, which I can't find, where he had ticked the box and said he wouldn't go forward if the fee is not waived. The court threw him out because they said to him, even though we think that you've got a very good case, when you went back to the first, if we let you go back to the first court, if you lost in the first court, you would need to appeal it, and you wouldn't have the money to appeal it because you said that you've got no money. So since we can't take the risk that we would waste the public money, that you would lose the case in the first court and you wouldn't have the money to go to the appeals court, therefore we're not going to let you back to the first court. Does everybody understand that, what I've said just then?
Yeah, yeah.
Right, so I never ticked that box. But you can go and have a look here. So we're up to here, right? So what he, look carefully what he said. He said that you ticked the box stating that you would start or continue the proceeding anyway. But what I actually said was, no. what I've got to do here, I think, is open. I think I can open it from here. Oh, none of them are coming up now. I'll open it.
Download it. It'll download, it'll come up.
Oh, I've got to turn that off. That's what I've got to do. Oh, no, none of them are opening. Hang on, I'll just enter again. Can you see that when I go there? Can you, is it still sharing or not?
No.
Oh,
We've
it's
got the
not?
Google screen.
All right, I'll just turn that one off. Sometimes you get these little
Now we've got your mail.
glitches. Right.
There we go.
Can you see it or not?
Oh, it was there. Now it's gone.
Yeah, that's all right, because I'll open up.
We're on your email now.
Right, I've opened up the application.
Oh, you've just lost it again.
No, I've got it. I'm just opening them all
Okay.
up
Good eye.
so that I can jump around where I want. Right, can you see that one?
Yep.
Yep, right. So you see here, he said that you took the box that you would start or continue anyway, but I actually didn't. What I did was, under our 1688, it doesn't matter if you've got money. That is irrelevant.
Correct.
So I said, yes, I would start the proceeding anyway. This is the catch-22. Because if you put here, if the application is refused, I will stop or discontinue with this proceeding, right? That means that you will not, appeal against the fee waiver declination. So that I said I would move forward with the proceeding in that I would appeal the declination. If the appeal of the declination was declined, I may or may not move forward with my substantive Supreme Court appeal. So, because of that, if I had have clicked, no, I will not move forward with the proceeding, and then if my fee had been declined, they wouldn't have accepted me appealing against the fee declination because I had already said that I wouldn't move forward if it was not waived. So that's a sneaky little thing they've got in there, hasn't it? So I thought, well, I'll click, I would continue anyway, but I said I would continue on the appeal of the declination. That's how I would continue. So is everybody clear on what I've said there? Or not?
Maybe you should have actually put in that spot then and there that it doesn't apply. It's not applicable. Not applicable under the 1688. So I don't know what their problem is.
Jody, you are brilliant. Brilliant, because I've got some news, because I am going to be able to use exactly what you've just said, and it has been on my mind, but it never occurred to me that I could put what you just said. But if you're coming up with that, then we can use it, because it means that other people are thinking the same. Jody, you're a freaking genius. You just come out with the best things. Right. So then he said, the application, he's turned around, so he said I did not meet BII, but he had not considered BI, which was the concerns, he has. He says, I'm also not satisfied that the requirement set out in BI has been met. The application and challenge of the Court of Appeal Judgment Brown raises issues specific to the applicant's application only. And the proposed appeal, he said, will not determine a question of law that is of significant interest to the public or a substantial section of the public. So he says it may be in the public interest, but it's not significant, the fee waiver. So I
No, well, it
missed out.
doesn't have to be, does it?
Exactly, no.
Well, it doesn't have to be, even if it.
And he does exactly what everybody else does. He just keeps throwing my pilot out and just coming back, and he has ignored the question of law, because in the Supreme Court fees regulations, wow, in the where's that section 14? Where is that, Maxine?
The court rules for Supreme.
Supreme, isn't it?
Yeah, I think so.
In the court rules 2016, in the court rules 2016, it says the costs are at the discretion of the court. In my point of law, costs at the discretion of the court, my point of law is that other provisions of any act override the clauses of 1 and 2. So any other act that says that you don't have to pay fees override this requirement to pay the fees. And he said that that's not a significant public interest issue. That's what he said. So
He's absolutely nuts. Sorry.
Yeah, because he said
He's
I don't
nuts.
have a point of law, but I did.
He's nuts. He's just throwing you out with the bathwater there.
But wait, because have a listen. Failure to meet the above criteria means that the application for fee waiver is consequently declined. The filing fee of $1,100 is now required to be paid immediately. Wait, Jody, because I'm going to tell you some good news. Please note that no further steps can be taken until the fee is paid. But the minute that I pay that, I've already lost Judge Brown's case. The minute. But here, listen. But then it says, in terms of 160 of the Senior Courts Act 2019, you may apply to a judge of the Supreme Court for a review of this decision within 20 working days, being notified of this decision within further time as the judge allows on the application. So what does that mean? That means that this is a great thing, because what that means now is we've left the registrar and we've ascended to the heavenly realm, because he's not able to make a decision like that. No. He really isn't.
No.
Because the question of law, so I don't think he is. So he's elevated us to the heavenly realm. He's allowing us to go to the Supreme Judge. So it's just a carbon copy of what happened in appeals court. The only difference is since that happened in the appeals court, 3 more cases have come to light. And Maxine just sent me one yesterday or the day before. Luckily, she's come back with us and she's all fired up and ready to go. And she has sent it to me, and we've got 3 cases where rulings have been made in regards to human rights, waiving fees, where we should be able to use the same thing in our 1688, and they weren't available to us in appeals. So people the judges have been following us, and I reckon this is going to go. So we have now, we've ascended to the heavenly realm of Supreme with Judge Brown, and now we have also ascended to the heavenly realm in regards to fees from the Supreme Court itself. So we're as high in the heavenly heavens, we're as high as you can go, the highest. And so there's going to be a big discussion about this now. So that I've got the 3 cases here, and we'll have to do another video on it, but we won't be doing that because I'll be working very strongly with Maxine. God bless, if she would be lovely enough to give us her time. And we'll be working with this, and I'll be writing up the case, and we'll be working with this. But that thing that you told me there, Jody, I want you to hang on to that for dear life. So go and write it down, because I'm going to forget it. Because I'm putting in all these, and I'm going to forget it. But that is really, really, really key.
Yeah, because I just wonder if you had put not applicable right at the very beginning, because by ticking a box, you're actually saying that you're acknowledging that there's a fee waiver.
No, because I did hear later.
There is a fee, you know, because we're going under the
No.
1688, the very, very first, I know there's a box that you would continue.
No, because now, so you all know where that is there, right? And the good thing is that here is my case. And this was this, so my actual case hasn't been declined.
Right, yeah.
So there's me, Catherine Ann Sixtus, there's Jacinda Ardern, and then these are, I'm the counsel, applicant in person. Then we've got PJ Gunn and McNamara for the respondents of Jacinda Ardern. Now we've got Palmer J down here from the first case. Yeah, now we've got Cook J. Now we've got JC McGrath. I've got them all in the court. Now we've got Brown J, and the new one is going to have Peter Greenhow.
Oh, there's got to be a song there, the cook in the kitchen with the Palmer outside, and the coat brown with the green.
Because at the end of the day, none of these guys have the balls to make a decision, and only the Supreme, because this is huge. That's why they won't make a decision. It's huge, the decision that's going to be made on this case. It's massive.
Yeah,
This could be our freedom back.
Yeah.
I fucking hope so. I hope so.
That's what she's saying. What Maxine's saying is that they can have their human rights if they want, but you don't get to, you don't get to trample all over ours in order to get yours. That's not right, and that's what this case is, because they keep saying that there's no case between the 1990 and the 16th. They said something. What did he say? That there was no dispute, and I'm saying there is a dispute. There is a dispute because I don't belong to any of their groups. I can't. There's nothing I can do to ever belong to any of their groups. There is nothing I can't change the color of my skin. I can't change that I have a husband and I like dick. Can't change that. Well, you can't.
Yeah, no, you're right.
Yeah.
And
Censored beep.
Well,
and I don't want to belong to those groups.
and there are
That
many
just-
people that don't want to belong to those
No.
groups. They want to stand in their own power. They're not
Yeah.
bound to their tribe. I mean, they've got their tribe, but
Yeah,
they
but-
are an entity in their own
Yeah,
right, in
that's
their
right.
own heavenly, godly power. They say, you know what, you're that tribe, and if I like something you want to do, I'm going to do it. But at the end of the day, you can't force me to do anything that I don't want to do
No.
just because I'm in that tribe. So I'm standing in my own power as the main power, and then you're the sidekick.
Yeah.
You're not over me. Is that right, Jody?
This resonates very much, Kate, to how we operate within our spirituality, religion, or whatever. They've got to go through a middleman. We're going straight as sovereign to the big man.
We go straight to God, because that is right. Because under those 3 biblical texts, it said that and now the Jehovah's Witnesses have written a new biblical text. They've got a brand new biblical text in a new language with all of their own laws, and they've added it. So there's actually 5 now. You've got the Catholic, you've got the Jewish one, you've got the Islamic one, right? And then you've got the St. James one, which is ours, and then you've got the new Jehovah's Witness one. So, and there's a secret, they're not letting them know the language. And in those 4 outside the St. James, in those 4, if you have any complaints about people within the church or whatever, you have to go through an intermediary who then goes to the apostles. But we said we don't want to do that. They said you have to go through us to get to the complaint. But we said we don't want to do that. We don't want to go through your barons. We don't want to go through your religious leaders. We want to go straight to God, all the way, directly to God, and bypass
in our sovereign right, in our own
sovereign right. And they can have it if they want it, but they would have to renounce their religion and their order to go through their leaders to get the thing that they want. They would have to renounce that, and they can't. So they came up with this human rights.
Is that why they get punished if they renounce it? Some religions punish them if they renounce.
It's the death penalty.
Yeah.
So that's why when Muslims came to our country, they had to make themselves subjects, and then they came under the no cruel and unusual punishment, and that released them from the death penalty that they were required to be under if they left their religion. The Catholics have got that as well. So have the Jews. They actually have it. If you leave their religion, it's the death penalty.
When did we stop this, making people subjects as they came into our countries?
In around about when they made us citizens.
Yeah, because it sort of sounds familiar. I remember the Bibles not being used in courts anymore, and taking them out of hotel rooms. You didn't have to have them anymore.
Yes.
Yep.
So let's not go on a tangent. Let's pay attention here. But that's exactly right. And then what Maxine was saying. So, and then what you're saying, Jody. So if they're all lined up there, and then we're going to finish this video soon. So I'll give it another 10 minutes. So you can see that, can't you? So then the original one that I sent, there's me, Catherine Ann Sixtus, and there's Maxine. She's a Will I Am. This name here is a very, very special name, because if it actually says Will I Am, it shouldn't have the S, but it actually says Will I Am. And this name comes directly from the will. Anyone with the name William comes from the will of Will I Am. And so that was very special that she's on there, that we've got Kate Can Do and Will I Am going in there. So that I said here that look how lovely it looks, but I don't think that I wrote this. It looks so beautiful. I had written, Catherine, the appellant in the proceeding, give you notice that I apply for the leave of the Supreme Court to appeal against the appeals court decision of Brown J to deny a fee waiver appeal of $1,100 and security costs. Jody told me to put that in, and I'm so grateful that I did. Set at $7,000 and a scheduling fee of $2,000. And then the particulars of the previous decision are a strikeout by Cook J in case management on May subsequent appeal by Ms. Sextus in June. I appealed that. Subsequently, a further application for a fee waiver of court costs 1,002 securities was made by Ms. Sextus and denied by J.C. McGrath. Based under Regulation 52B, Court of Appeals, including Regulation 54A and 54B, which are the same as the ones that we just looked at before, of the you need to be a group. What are this is their question. What are the specific grounds of the proposed appeal? The grounds that I, Catherine Ann Sextus, dispute is Brown J, based on 2 points of contention. First, the requirements of Regulation 54 to receive a fee waiver, he said they apply to Ms. Sextus, irrespective of the jurisdictional route invoked. Now, if you go under the human rights, the fee waiver applies. No. If you go under the human rights, the fee waiver applies if you belong to one of their special groups. But if you don't belong to any of their groups, you can't. Did you know this? If you don't belong to one of their groups, you can't even use the 1990 Bill of Rights. The only way that you're allowed to use the 1990 Bill of Rights is if you belong to one of their groups. So if you don't belong to them, you can't even use it. So all those people that don't belong to those, so you can get your fee waiver there, or the other jurisdictional route is the 1688 Bill of Rights under, as an individual, it says all commitments for petitioning in regards to that Bill of Rights only are free from commitment or free from having to pay fees if you just want to have a question of law that's repugnant. Well, he has said that it doesn't matter which jurisdictional route that you use, you have to follow 5.4, which means you have to have a group. So I've disputed that. The High Court rules 14.1, I said, the High Court rules 14.1 costs are at the discretion of the court provides that the provisions of any act override subclauses 1 and 2. You can see that here in 14. It says here, the provisions of any act override subclauses 1 and 2 of having to pay court costs, right? So then I said that the Human Rights Act, Section 125, is one such provision, and that comes under a court ruling of Hinton J, which we'll do that court ruling later, all right? But I said also the 1688 Will and Mary, Bill of Rights 1688 reprint, so it didn't used to be called a bill, it used to be called a will, and now they've made it into a bill, which is, it's actually a bill to Parliament, not a bill to us. The right to petition is one such provision, that it is the right of the subject to petition the king, and all commitments and prosecutions for such petition are illegal. The provision that all commitments are illegal when applying for a declaration of right includes security fee when petitioning a question of law by the state. Is everybody's with me? Yeah. So I said that there are 2 jurisdictions where fee waivers may apply that would counteract this court rule here, 1 and 2. So there's 2 jurisdictions. One is the Human Rights Act, if you belong to the group. The other one is the 1688, and they can override all of that. So that is what we're taking to the big Supreme to get that ruling. So response. Also, I'm saying that Brown J then went on to say, the reference to Miss Sextus, remember I talked about the ordinances, that all people that were sent to these countries were given ordinances if they were pre-1852. Pre-1852, and I'm thinking over in Australia, it was pre-1901, because they had no constitution. So the ordinances made us, he said concerning the naturalization of German settlers in the colony, but no, Miss Sextus notes that Judge Brown noted that Miss Sextus may bring proceedings in the New Zealand courts as a citizen like any other New Zealanders, but he did not consider any particular right as a subject as being valid to my person that is free in nature. So I went into the court as a subject. So I went here and I said, I'm a subject, and so therefore I come under the 1688 will, and therefore I'm allowed to have the right to petition the king under and override your fees. That's what I've said. And I said, I want to be a subject. And he said, you're not a subject, you're a citizen. And my response to him in my appeal is that in the Treaty of Waitangi, the preamble states that Her Majesty's desire to establish a civil government to Her Majesty's subjects, the German Settlers Ordinance of 1844, the 1847 Ordinance of Tamati Wakanene, and Scottish ordinances in New Zealand that occurred pre-1852 to 1858 are of direct lineage to Her Majesty's governance on the 14th of January 1840 and the Treaty of Waitangi. All persons described in the schedule annexed 1844 to the schedule of the treaty are deemed to be and taken to be and to have been natural born subjects of Her Majesty. I should have put his. Based on the 1688 will and Mary that as subjects described and annexed, they will be allowed their liberties or air liberties for all times to come. Being a citizen of New Zealand cannot abrogate nor restrict my existing ancient subject right, dated 14th day of June 1843 by Her Majesty Queen Victoria at Westminster and presently deemed and taken to be His Majesty King Charles III under Almighty God. So does everybody understand all that? Why is everyone quiet?
We're on mute. I said yes.
Does everybody all understand that? Then I've
Yep.
said, I do pray that it may be declared and claimed in a declaration that my singular person may continue to assert all and every particular of my own true, ancient, indubitable right for all times to come as an integral part of the duty of the state to protect my individual person independently from the collective state of citizenship. And then it said, why should the Supreme Court give leave to the proposed appeal? And then I've put, the appeal involves a matter of general public importance. Now, Jody, I might have made a mistake here. Reasons I've given, there are possibly as many as 2 million descendants of various ordinances pre-1852 that were agreed to by Westminster, the New Zealand Company and independent paramount chief Tamati Wakanene, Thomas Wakanene, and other significant paramount chiefs signatories to the Treaty of Waitangi. Tamati Wakanene was in 1847 a sworn, recognized government official, and as such, the ordinances must be considered by the Treaty of Waitangi Tribunal and the Crown as an equity defence where estoppel applies. The receivers of the ordinance believed that their rights as subjects described in the 1688 Will and Mary would be honoured by all parties that were signatories to the treaty for all times to come. A substantial miscarriage of justice may have occurred. We have to put in if there was a substantial miscarriage of justice. And I've said a substantial miscarriage of justice occurred and may continue to occur if the schedules of the ordinances pre-1852 are defaulted on by the New Zealand Maori and the Crown as set out in S6 and S9 of the Treaty of Waitangi 2018, whereby such actions may prejudicially affect such particular persons as annexed and described in schedule of, fucking who wrote this? Did I even write this?
You did.
In schedule of 1844 German Settlers Ordinance, which is prescribed in S9 of the Treaty of Waitangi. Now, what you need to know here is that there are 3 treaties. The only original treaty was S9 of the treaty number 114. That was the one that was ascended. In 2018 and 2022, they removed S9. S9 says that all rights to petition to the Parliament or any bodies associated by the Parliament would be unaffected. That was removed for the Anglo people, and it was only put in place for the Maori people. So they removed it in 2018 and 2022. Not sure if I've made that quite clear in there, but the fact that it's in there, I can reverberate on that in the application to the appeals. For the purposes of subsection 2, a significant issue relating to the treaty is a matter of public importance. And I think that this is because they've removed our rights. And I don't belong to a group.
But again, you don't have to have public importance because it's not under your claim under the 1688, it's not applicable.
What I'm going to do, Jodie, is I'm going to come back in and do a private lesson with you, and we're going to discuss the merits of what you're saying and what I've got and how we can change it. All right, so we'll do that in another thing. But we definitely have to have a one-on-one, you and me, if you've got the time, and I would be blessed to have you. Reasons, the significant issue is that the treaty, this is what I'm saying, the treaty as a whole document has merit. So what they're doing is picking and choosing pieces of the treaty when they feel like it, and picking and choosing not to use when they feel like it. I'm saying it has to be recognised as a whole document in all its entirety, with the preamble focus of the right and governance to the subjects. Here's what it says. These are who the Pākehā are. To the subjects coming from Europe and Australia. Then it only asks the New Zealanders, which were the Maori called New Zealanders back then, to concur on the following 3 articles. That was the 3 articles where they asked them if they wanted to become subjects, and if they wanted to put the lands in the safety of the Queen. The preamble has, and so for that period of time, nobody was allowed to enter New Zealand or Australia or Canada. No one was allowed to enter to go and live there, and none of them were allowed to buy land. The only people allowed to do that were subjects, and that's why they call it the white supremacy, because none of the Browns from the Asian countries were allowed to go in, because they weren't restricted on buying up the native lands. That's why. It was nothing to do with it being racist. It was to do with, it was to protect their lands for them. And we all sacrificed our lives and our own native lands to save their native lands. That's what had happened. They should be bloody welcoming us on the marae and giving us parties every week with lots of beer. Right. The preamble, so it had significant protections and just rights to all European and Australian people and all New Zealanders that choose to be subjects of His Majesty by birthright, by descent, and or by oath of allegiance. These English rights preserved by the Treaty of Waitangi cannot be held to be abrogated by any act of Parliament, such as they did in here in 218 and 222. Thereby, it is the right to petition the King, and all commitments and prosecutions for doing so are illegal. What is the judgment that you seek? I'm seeking two judgments. May it please the Supreme Court to consider that under S1 of the Bill of Rights 1688, 2015, and Section 9 of the Treaty of Waitangi 1975, number 114, not the 2018 version. The right to petition, respectively, the preamble of the Treaty of Waitangi would override the costs provisions in Part 14 of the High Court rules. Such right provides that all commitments for such petitioning are illegal and override Part 14 costs at discretion of the court of the High Court rules and displacing the normal rule in terms of security costs by 14.3. So I've said now, I want you to remember what I'm going to say because it's going to come up later. So here it overrides, but he only got it to override in regards to court costs. He didn't get it to override in regards to security fee, because the court in that case for Arthur Taylor, he said, we accept that the court costs can be overridden, but he said that doesn't include security. It doesn't displace the security fee, which has nothing to do with the court. That's to do with the lawyers of the defendants, that they want a security fee, that if they win, that they're going to get their money back. But I have said that it displaces the normal rule. Also, thanks to Jody, this is thanks to Jody that I got this. It does displace the normal rule in terms of security costs, because ours says all commitments are illegal.
And Kate,
yes,
that security fee is for the lawyers. We are going
Yes.
in by ourselves, not with lawyers, because we're not asking for recompense.
it's not for our
not
lawyers, it's for
compensation.
their lawyers, but
It's for
that's another video, because it's
Yes,
because
yeah.
of the cabinet manual says that whenever we call the Crown Law to the court, we don't have to pay for it because we already paid them. But that's another issue. We won't talk about it today, Jody, but I've put that in anyway, that it does also displace the security cost, which is for their lawyer, not for our lawyer, for their lawyer, Jacinda's lawyer. I do pray a declaration of right. I'm asking for two prayers. I do pray a declaration of right from the Supreme Court of New Zealand that all ordinances declared after the 14th of January and after the signing of the Treaty of Waitangi, and all persons scheduled and their descendants annexed to such ordinances and treaties shall be deemed and taken to be and to have been and continue to be by their right natural born subjects of His Majesty if they so choose, and such right by the 1688 will and Mary cannot by law be held to be abrogated by any tribunal, nor any court, nor any act. And then my song, what is right, what is wrong by the law, by the law. What is right, what is wrong by the law, by the law. Ye Jacobites by name, send an ear, send an ear. What is right, what is wrong by the law. So help me God. So that is all So we've got our fee waivers application here that I continued here to use all of these things here in the fee waiver application, right? And I've used all of that. And I have said that basically they override any of the fees. And yes, and so Jodie's bringing up the group thing again, but I haven't mentioned it about the group in my application. Oh, Jodie. I've done it again, haven't I, Jodie? Well, because, that's the problem, because I go and say that it is of significant, but I should just be saying I don't need a group. But I have put that in there because I have, all right, but I have put in there.
You could almost say that it's not needed, but if you know, it is of significance anyway, so it should be allowed no matter what. It fits the bill for both.
I just, it just says the provisions of any act override clause 1 and 2. So that would override any requirement of having a group or any, it would override anything, any clause that they have. So I can say I'm a group or not, it would override it because it
the fact that we have to go and regurgitate their crap through those flippin' legislation back to them to try and justify what we know to be true because it's in their legislation is out the gate. All we're doing in your all you're doing there is trying to show them registrars that should be educated what their law's telling them. That's what you're saying. You're saying to them, and we shouldn't have to do that. They should know this stuff.
That's right. They should be the ones helping.
Here we are as going, it feels like we're going cap in hand to say, look what your law says. Look what your law says. Look, it tells us here that we can come in. We don't need to be part of a group. I mean, I don't think you're missing out not being part of one of those groups because who wants to be part of that? But
exactly.
like they're a sick bunch of.
They're asking for too much. They've given themselves all sorts of privileges. That's all paid by all of us. We're all going to foot the bill, even if you're.
But even sitting here trying to proffer send in an application to the court that should know this stuff and show them their legislation as to why we should be coming in without a paying a fee. It's just out the gate. They should know this.
They're not learned in
a conversation.
They're not learned in the constitutional High Supreme.
But then they haven't got the balls either because they want a judge to do it. They don't want to do it.
Yeah.
All those registrars aren't willing to put their, to stand by their job and make a decision. They're not willing to do that. I mean, it's huge and I understand why they'd rather a judge do it. But it's like, have some balls and start changing what's, start standing up for our law.
Yeah.
Otherwise, what's a country without a law?
Exactly. Right. Well, I just going on what Maxine has just said, but I think this is the same Peter Greenhow. It says Peter Greenhow, Supreme Court of New Zealand. Now let's have a look at his resume, shall we? So these are the judges that we've got in the Supreme Court. Here's his resume. So he was a retail salesman for the Farmers Trading Company for 2 years, 8 months in 2013.
That's not surprising because
Then-
the ads of for to do this, you don't have to have any experience to
Yeah,
become a
he-
one to do what he's doing.
He became a collections registry officer for 1 year and 5 months in 2019.
Oh shit.
And then he became a case manager for ACC appeals in 2020 for a year. And then he just jumped all the way up to the Supreme Court to make rulings
No.
on me as a court registry officer. And suddenly he spends 4 years at the Ministry of Justice, and he's now a technical specialist on constitutional law in the Supreme Court of New Zealand for 5 months.
Oh my goodness.
So these are the people that are
Yeah.
making constitution. He's a constitutional technical specialist, apparently, on constitutional law in the Supreme Court of New Zealand. And so he's made this ruling that all of my stuff is irrelevant. So I'm just like, I don't see how.
He's a
I don't
specialist.
know. So we're gonna have just a couple of minutes talk, and then I'm gonna get off this video. It's ended up being a 2-hour video. It was only supposed to be a 1-hour video, but it's been 2 hours. But we've discussed this is a really important video. It's got a lot of stuff in there. It goes right back to where it all begins, comes into the laws, and it shows where we all are now. So this is a great video, and we'll be able to put it up for everyone. There's Brent. So this is Kate Floss and the Oreo team. Sharon has not been able to be with us today. And usually Diane, who's also in the Oreo team. We're just a team of people that have gotten together that we want to find a way to not be bound by the United Nations laws and to have more power to go to the courts and hold the parliamentarians to account. It's how is it that they're allowed to make a law? So they made a law in the Daniel Fitzgerald case. They made a law and they were warned. They were warned. I'm not going to do that case on here. But they were warned not to make that law, and they made the law anyway. And a few years later, it ended up going to the court. A man spent 5 years of his life in prison when he wasn't supposed to because they ignored that law. And then the taxpayers ended up having Brent, and the taxpayers had to end up paying $450,000 in compensation to that man. And the law that they were warned not to make in the first place, after hundreds of thousands of dollars in court fees and appeals and 5 years in a prison, which was all paid for by the taxpayer, which is thousands of dollars to keep a person in prison. Altogether, it cost, because they ignored what they were supposed to do, they ignored the warning. It cost the New Zealand people, it would have been upwards of around $5 million for this one man. And we should always have the right to be able to look at a law and say, hey, we as a people that have to pay for that have the right, because they've said in their ruling, it's not fair for the taxpayers. It's not fair for us to let a case into the court if we think that it's not really going to be a good question of law and the taxpayers will have to pay it. Well, had the taxpayer been able to to contest what the government did at that time, it would have cost the taxpayers probably about maybe $100,000 to get that case. But instead, because the taxpayers were not able to go and hold the parliament to account, the taxpayers ended up losing upwards of $5 million on one case through that 1990 Bill of Rights and the Human Rights Law. So we've got, so I think they should not be allowed to take that right away from us.
No.
Brent, I'm sorry. And now I can't hear
You
you.
now.
I didn't even do any. I didn't even do any.
You're rubbing your tummy with your mic. That doesn't sound right.
The noise, Brent, it makes every time you move or even breathe, the noise comes
Yeah.
on the thing, doesn't it? And we can hear it, can't we? And it's loud in our ears.
Oh Jesus! Oh, I don't know how to stop that.
Yeah. Mute it.
I did mute it.
Yeah, but not when you want to speak. When you want to speak, you unmute it and then you speak. And then when you finish speaking, then you put it mute again, Brent.
I
Do you
know he's
understand
frozen up.
No, you're there. We see you. That's
No,
Maxine.
you
I'm frozen.
froze up at my end.
I'm not frozen, am I?
No, we were just all frozen in amazement. Anyway,
Nah, no, when you want to talk, put it on. And then when you're not talking.
you want to stop recording?
Yeah.
No, I thought I'd just do that because I wanted to let everyone know that I'm not angry with Brent. He's great, but only that when he puts his microphone on, sometimes he starts moving. When he moves, it makes a loud noise. So we ask him to turn off his microphone, but he always forgets. But now it's quiet, isn't
Yeah.
it? Why is there no sound now?
Maybe because I turned my mic down a bit, the sound down a bit.
Oh, yeah. Anyway, that's all right. So we're going to stop the recording. So this is the Oreo team. We've got Jody, who's been very helpful. Maxine, Jody is the idea person. She really comes up with good ideas. And Maxine is the legal. She's Morpheus. Is it Morpheus? She's the one that comes. She finds a lot of these cases. She just found a really important case for me from Palmer J that was only just recently. So she's the one that keeps up with the up-to-dates because I'm busy writing all of the things and I'm not able to see what's going on. So Maxine is absolutely instrumental in that for us. And Diane and Brent, we don't know what we love them, don't we? And
Brent spreads the word.
And Sharon's not here, but Sharon's also
Okay.
very good because she's good. I have some private videos sometimes with her. She's really, really excellent. She fills us in on the history of the New Zealand natives and she keeps us all up. If we want to know if something's right or not, we just ask her and she lets us know about that. And so that's our Oreo team. We are definitely a team. None of us could do it without each other. We're hoping to get something out of this. We don't know what we're going to get, but we did just see an Australian group talking about that they're able to go to Westminster, and so now we've elevated to the Supreme Court outside of the retail salesperson who is now a Supreme Court judge. We've elevated out of him to a proper Supreme Court judge who, if we lost that case, we might possibly be able to go to Westminster. So I'm going to have to get on here with Jody. We're going to have to talk about that. I did use the thing that I'm good, but I think I can be either or. I think I can have a public interest or not. If I don't have the public interest, then I override. If I do have the public interest, I get. I think I can come from both sides of the coin.
I think there's no doubt about that. What I think is that they are reading this shit. They don't know what they're doing. They have no idea about it because they don't know what they have no idea what you've given them. So they're just spouting back the legislation that they know. That's all they're doing.
Mm.
Yeah.
and they let it go to the judge. That's all they're doing. It's not that we should prove it, because how do you prove it to someone that does not have the capability to understand what you're trying to show them? Because they don't. They don't have the capability.
And it's probably not in their powers to really make a ruling per se.
No.
It has to go through to the judge anyway.
That's
So,
right.
you know, it's too, you wouldn't want to be a registrar if you had that kind of responsibility. That's what judges are for.
And he did he did not turn down the application of the first
No.
one. He has turned it down. He said, now you've just got a whole new case with us. So he
Yep.
said, that's that case there. And that's because I was confused, because in their one, they're different, because in the appeals one, you put in the application first, the application,
Yeah.
the application to appeal from the first court, and then that gets accepted. And then if it's accepted, then you put in for the fee waiver. But the Supreme Court was different. Supreme Court, you had to put in, or no, you put in the, I can't remember, but anyway, it's a little bit round the back to front, because I was thinking, well, in order to get my case from appeals heard, I would have to pay the Supreme fee. So I was wondering how I would get, but he's just fixed it all for me, so that he just sends me straight to the Supreme, and then the ruling will be the supremest ruling, and then it will trickle all back down, because that will reverberate right down, back down again. So that's how it couldn't have happened any other way, I don't think. I'm very pleased with what he's done.
I think that
I think it's set up that way. Honestly. I mean, they can't have registrars making rulings or whatever for things like this. It just doesn't make sense. They'd have to, I don't know. It's almost like
I don't
a
think they ever.
hard basket box. Here's Supreme Court. You deal with it.
I don't think they
Yeah.
ever thought that someone would come in with the 1688 and show them that you can go to court and not pay a fee. I
That's
reckon
right,
that's what
Maxine.
happened.
They're all walking around there with their heads in their hands, freaking out, wondering how the hell they're going to deal with this. They got no idea what the can of worms that's been opened. They know what the can of worms
know
is,
what's going
and they're
on.
all shitting themselves, and they haven't got a leg to stand on.
It's highly possible that the only answer could come from Westminster.
Yeah.
These guys have they don't know. You're dealing with people that don't know, that haven't been educated in this.
Or not necessarily don't know, but they don't want to take that responsibility either. I mean, even a 5-month-old judge doesn't want that responsibility. So he's going to say, you need something, and he'll kick it off.
That's just they're going to be ruling for us.
If we go to Westminster,
What you're saying here, so we can't be saying things against the judges, because those are the ones that we need to help us. So
yeah, but if we end up having to go to Westminster,
be respectful.
But it could be any judge. It could be any judge. They don't want to handle this situation because it's such a big bundle that only Westminster can deal with it. So they make up a plan path that this is okay. Now we can kick you off up there.
yeah, maybe that's what they've done already.
I think so.
Well, we have to be respectful. We have to, I'm looking at all the rulings, and they do seem to be following the laws, but I only see with the registrars is the registrar just put up, just like they did in appeals, the registrars only just put up that law that they're trained. They don't make any decisions on any other issue. They only just put up that law of the 5-2 or whatever it is. When it went to Justice Brown, he is the one that actually made a ruling, and that's going to be the same now. This registrar was not able to make a ruling. on the things that I said. So he just put that rule up there, and he said, but you can go up to the proper judge, and then that's when that'll go. And I assume we'll find out the proper judge, just like Justice Brown, the proper
give a
Supreme Court judge will then make the ruling. Now, if the proper Supreme Court judge came back with the same thing as the registrar, we would be able to complain, but we've got to wait for a minute because Judge Brown didn't. Judge Brown made our whole thing clear, and he came back with 2 issues, and he said, what have you got to say about that, Kate Floss? And I went to the registrar, and I said, this is what I've got to say about that. The registrar is not in any power, I think, to overrule an appeals court judge, because I know
No way.
no, you're not allowed to, because it's been in a case. So it's impossible for him to do that. So he says, I'm in agreement with this law here, and so I'm going to send you up to the proper judge who's going to make rulings on all those issues that you've put up there, because he can't. Because I know that when you're in the teaching in the school, a professor degree is allowed to teach a doctorate degree. A doctorate degree person is allowed to teach a bachelor's degree class, and a bachelor's degree is allowed to teach in the high school. So they're not allowed. So someone with a bachelor's degree is forbidden to teach people with a doctor's, wanting to get a doctor's degree, because they're not knowledgeable. It's the same in the court. A registrar can't really overrule anything on a high court appeals court judge. But all they can do is say that this is the law that he saw, this is the law that I saw, and go back up to a higher judge, and it's the judge that will do it. So we mustn't be saying that they're doing things wrong, because what I can see, they're doing everything in the correct way, and we're just being shoved up. We are at the toppest end of the realm, cannot go any further. And then we'll see how we go there. And then, as you all say, Westminster, but we must not discount that judge just yet, because we don't know what he's going to say. We
don't know. No.
Well,
We-
if we wind up at Westminster, I'm going to start a GoFundMe page to get us all there.
Hopefully, well, what I'm hoping for is that that there is enough support for these laws in New Zealand that there are judges sitting there that we're waiting for something like this
Yeah.
to put us back to where we were, or something close to it. I don't expect to go back to where we were, but just honour the stuff that's been given to us. That's all I want. Honour it, and honour that. There's no honour from what's happening. The 1990 Aotearoa, all that. There's no honour in that. There's just nothing. There's nothing there.
Well, this is going to have great effect for Australia too, and it's also going to have an effect for England too, because let's just remember here, this has been removed from the English, the Scottish, the Irish, and Australia and New Zealand. It's been removed from all our Anglo countries. But let me tell you this much, Canada and America is the one that started the United Nations. That's one. And number two, America fought and got the English out and tried to remove their subject status, but they weren't able to do it. And three, both Canada and America separated their native people from the indigenous group of the refugees at the United Nations, and they put in protections for all of their native lands and for all of their Anglo lands. They put in there that all of the America wrote their own American Indian Indigenous rights, called the American Indian Indigenous Rights. And in there they said these rights will have no effect on any of the states that were already settled on or something by the American people. So it would the only place that these rights would have an effect in regards to their lands was all the lands that they already had from all the territories that were mapped out as being their territories. They didn't inhabit the entire American states. So the Anglo people went into all the states that were not inhabited. But all the territories that were inhabited by the native Indians, that's where all their Indigenous rights and land rights applied to those areas. But they protected the other areas. That's what America did. And then they didn't do that for us. They just said, oh, we're just going to take all that land back from you, even though you bought it, even though you've lived here for a couple of hundred years, and we're just going to give it to the islanders. We're going to give it to the islanders and the refugees. We're just going to give it all to them, and you're all going to be.
And we're going to pay for it.
And we're going to pay for it.
Yeah.
And we're going to pay for it. So Canada protected themselves as well. And they've got a law that says that all the human rights is not applicable unless they decide that it is applicable. They said they have the right to override it at any time.
Tonga don't think they're human rights either, do they?
No, Tonga does not even recognise that human rights exist. They said it's not in their language, therefore they don't recognise it. Samoa's the same.
It's just us.
It's only us.
It's just New
Australia,
Zealand
it's
and
England,
Māori and
Ireland, it's England, Ireland, Scotland, Australia, New Zealand, Tokelau, New and Cook Islands. Tokelau, New and Cook Islands have sold out to the other islands, so we've lost them. So that's what we're fighting for, our everything. Anyway, we better hang up this video. I'm going to stop the recording.
Stop the recording, and then I'll have a
Smile.
chat.
it takes ages. What's it on? I went into there and I couldn't see it.
Is it off? Is the recording
No,
off?
it's still recording.
I'm getting my best face. Hang on.
Oh God, Kate.
It's still recording.
I know. All right. What side or front?
Oh my God.
Oh, that's a
The
good
back
one.
of your head.
Yeah, I like this one. Hang on.
God.
Ah, it's not up.